Register every day at the firms that are giving away this wonderful 7-day vacation in Miami Beach. WJQS will draw the winner's name the last of April. Stop by and register today at the following firms.
Bob's Furniture House, 644 South Gallatin, the Dollar Store, corner of Capitol and Parrish. Wilson Geyer Paint.
You haven't heard about the deputy state by the Lamar Life Insurance Company. Now today's comment by Bill Miner, Mississippi correspondent for the New Orleans Times-Picayune.
Good evening. Well, it seems to be that season again when some of the state legislators start thinking up ways to tell the educators what to teach in the textbooks that they will use in Mississippi. This newest drive has the marks of becoming perhaps the rawest bid by politicians to dabble in the academic side of the school system that has come along since this became a popular sport a few years back. And the educators who were in town last week in the annual state teachers convention, let it be known that they resent the continuing legislative effort to interfere in the school curriculum. Said one educator who headed a committee which is designed to upgrade teaching standards, he said, the real danger in this state is that the wrong people are trying to get control of the textbooks and the curriculum. What outraged many of the educators, that is, was the bill that was introduced a few days before the teachers came to town to ban 35 textbooks, many of them that have been used for years in the high schools of the state, from the public school system. The author of the bill, Senator Hugh Bailey of Winona, had gained some notoriety 2 years ago when he rode a donkey from his hometown to take his seat in the state senate. Bailey admitted last week to a reporter that all he knew about the books was what he had been told by some ladies of the Daughters of the American Revolution, and that the texts were hot off the DAR's black list. 3 years ago, at the insistence of the ladies of the DAR, the General Legislative Investigating Committee had made an investigation of 27 textbooks which the ladies considered unsatisfactory because they did not coincide with their views in some aspects. The committee had hired a retired Indiana school teacher, E. Merrill Root, to examine the books and make an evaluation of them. Root had been suggested for the study by the DAR. Out of the 27 books, Root found 12 of them unsatisfactory, and the rest, he said, were either mediocre or satisfactory. Most of the objections he found were aimed at what he considered examples of collectivism and reflected heavily the DAR's opposition to such institutions as the United Nations and some authors and poets, including Archibald MacLeish and Carl Sandburg. Strangely enough, the Bailey bill goes beyond the Root evaluation and would toss out books which Root had said were not only satisfactory, but some of which he praised. And that's the way it looks from here today.
Time waits for no one, least of all the children. Those children of yours seemingly grow up overnight and are ready for college. You can assure their college education with a Lamar Life educational policy. A little saved in a Lamar Life educational policy now will pay for that important college education. Your Lamar Life agent will be glad to give you all the details about these policies. Don't wait. See the Lamar Life agent in your community. Most important, see him soon. Plan now to use this important service of Lamar Life Insurance Company, a tower of strength in the Deep South. You've been listening to comment by Bill Miner, one of a group of well-known newsmen who appear in this series weekdays. The views expressed on this program are not necessarily those of the sponsor or this station. Join us again tomorrow at 5:35 for Channel 3's Comment, presented by the Lamar Life Insurance Company.
Because Niagara is the instant dry starch, the only one you can pour right from the package into your washer. Niagara gives deep, penetrating action to protect and beautify your fabric. Curtains have a just right, longer-lasting finish with Niagara. They're evenly starched, uniformly lovely from top to bottom. Even slipcovers look nicer, newer with Niagara. Sheets are crisply fresh, never stiff or boardy, but invitingly smooth, cool, so refreshing to the touch.
Washer starting with Niagara. Starting right here.
Instant Niagara with washer starching is so effective it has earned the Good Housekeeping seal.
It's time now for highlights in the world of sports presented by WLBT.
Company and your nearby SO dealers. And now the news. In brief, President Kennedy at a news conference this afternoon said he was gratified at Soviet Premier Khrushchev's response to proposals for cooperation in space developments. Mr. Kennedy said Khrushchev indicated a number of areas for possible agreement. The president also said he believes the Geneva Conference on Disarmament should continue despite what he calls basic differences between the U.S. and Russia. The U.S. and the Soviet Union are reported in complete deadlock on major Cold War issues at the Geneva talks. The House called off a floor fight today regarding the controversial B-70 bomber after President Kennedy and Defense Secretary McNamara worked out a last-minute compromise with the House Armed Services Committee. Here in Mississippi, the Senate has passed a bill merging the 2nd and 3rd congressional districts of North Mississippi. If passed by the House, the measure will put Congressman Frank Smith and Jamie Whitten in a runoff election in the June Democratic primary. The new Veterans Administration Hospital in Jackson will be dedicated in ceremonies 1 week from Sunday. We'll have a film report on the $14 million Veterans Center. News in detail, President Kennedy has welcomed Premier Khrushchev's reply to his proposals for cooperation in space work. He said he is gratified that the Khrushchev letter indicates a number of areas for possible agreement.
Reply to my letter of March 7th on outer space cooperation. I am gratified that this reply indicates that there are a number of areas of common interest. The next step clearly is for the United States representative on the UN Outer Space Committee, Ambassador Francis Plimpton, to meet in New York with the Soviet representative to make arrangements for an early discussion of the specific ideas of the Soviet Union and the United States. I have designated Dr. Hugh Dryden, Deputy Administrator of the National Aeronautics and Space Administration, to take the lead for the United States this time in subsequent technical talks with Soviet representatives. The United States is deeply committed to making all possible efforts to carry forward the exploration and use of space in a spirit of cooperation and for the benefit of all mankind. I'm hopeful that there will be in this area prospects for practical cooperation.
The President also told newsmen he is not ready to abandon hope for the Geneva Disarmament Conference. He said, "I think the talks should go on." Mr. Kennedy refused to continue the controversy over recent charges by Richard Nixon. Nixon said Mr. Kennedy had advanced intelligence information when he made a campaign proposal to aid anti-Castro Cuba. The White House has denied this. He strongly disputed critics of his medical care proposals who call it an opening wedge for socialized medicine. He called this an old argument that is always used when a case is lost. The President said news that Cuba plans to try the prisoners captured in the unsuccessful invasion attempt as a matter of great national and personal distress. He also said the U.S. will take proper action when a new government actually is formed in Algeria. The United States and Russia are said to be in a complete deadlock at Geneva on the major Cold War issues, Berlin, and a nuclear test ban. Secretary of State Rusk and Russian Foreign Minister Gromyko will continue their meetings, but no progress is expected before they leave for home next week. President Kennedy has worked out a compromise to avoid a congressional battle over the program for development of the RF-70 jet bomber. He told the House Armed Services Committee a study will be made to determine whether it would be worthwhile to spend more money on the development program. Senate leaders have decided not to force a vote on cutting off debate on proposals to outlaw the poll tax. However, as the talkathon against the proposals goes on, the Senate will continue to convene 3 hours earlier than usual. All committee meetings are still forbidden. Russian and Allied planes flew through the Berlin air corridor today at the same altitude at the same time. No incidents developed. Russian jets also boomed through the sound barrier over West Berlin, rattling windows and startling Berliners. More news in a moment.
Recognize the tune? It's Happy, Esso's cheerful symbol of happy motoring. Happy has a personal question for you. Want to get the most out of driving? No more lagging at lights? No more creeping up hills? No more huffing and puffing your way along the highway? Well, if you do, then follow this happy tune. To the Esso sign and fill up with Esso Extra gasoline. Created through atomic research, Esso Extra brings you an outstanding all-round combination of driving advantages for happy motoring. Yes, your car will sing a happy tune, and you will too with Esso Extra, today's greatest value in premium gasoline. Millions use it, and they like it. Another good reason why the Esso sign is the world's first choice.
1 week from Sunday, on April the 1st, the new $14 million Veterans Hospital and Regional Offices building on Woodrow Wilson Drive in Jackson will be dedicated. National and state dignitaries will be on hand for the occasion. An open house will be held following the ceremonies. WLBT News will present a complete film report on the new VA Center this Sunday on Dick Sanders' Sunday Report. Here's a portion of the story filmed this morning by WLBT photographer Cliff Bingham. The new building was occupied January 30th of this year, moving from the old quarters in West Jackson on Lindbergh Drive. Construction began in the summer of 1959. One of 13 40-bed nursing stations in the 500-bed hospital. Each room has a 4-channel radio set up for patients. And a unique intercom system enables the nurse at the nursing station to speak with patients in their rooms. In all, there are between 9 and 10 acres of floor space in the building. A total of about 800 employees in the hospital and regional offices combined. A spacious canteen, which is self-supporting, operating on a low profit margin for the benefit of the patients, visitors, and employees. The kitchen for a building of this size is immense. The main kitchen, then there are floor kitchens on each of the floors with dumbwaiter service. And 74 kitchen employees in all. There are 30 full-time positions at the new Veterans Hospital, about 80 attending consultants, and some 90 nurses. On Sunday, on Dick Sanders' Sunday Report, WLBT News will present a full film report on the new $14 million Veterans Center in Jackson. Well, the American Red Cross reports that it spent more than $1 million for emergency assistance in Mississippi in 1961. Red Cross Field Representative Joe Ferguson of Jackson says that nearly $656,000 was spent for disaster assistance, and more than $350,000 went for blood and blood derivatives. Ferguson presented the report to Governor Barnett in connection with the organization's annual funds and membership campaign. The queen of the 25th Annual Southeast Mississippi Livestock Show will be crowned at Forest. The 4-day show should be crowned tonight. The 4-day show began this afternoon with a parade. The judging contest and the baby beef show will be held tomorrow. The senior beef show will be on Friday and the auction on Saturday. Well, fair and cool is the forecast for the central area of the state. The low tonight in the low 40s, the high tomorrow near 70. More news in a moment.
These are the hands of service. Good, capable hands. Helpful hands in 100 ways. The kind you seem to find more of at Esso stations than anywhere else. In fact, everything you need for happy motoring is yours at the Esso sign.
Well, today is the first full day of spring, but everything imaginable happens in the nation's weather today. Rain, snow, floods, tornadoes, ice jams, and dust storms. Well, that's the up-to-the-minute news brought to you by Humble Oil and Refining Company, America's leading energy company, and your nearby SO dealer. Until tomorrow at the same time, this is Hagen Thompson, your SO reporter, saying good night. Have a good day tomorrow.
There's something new in whiteness. Because there's something new in Oxidol.
What are those little green things? What do they do?
I don't know, but I sure like the washes I've been getting lately.
There's something new in whiteness. Because there's something new in Oxidol.
Oh, look, there's that new Oxidol label was texting us about.
With green crystals contains bleach color safe.
I'll try anything once.
There's something new in whiteness. Because there's something new in Oxidol.
My kid's t-shirts look terrible. How do you get yours so white?
Must be that new Oxidol. Has a bleaching.
Yes, there's something new in whiteness. Because there's something new in Oxidol. It's green crystals. They contain a special kind of bleach. And only new Oxidol got them. Yes, new Oxidol gets colored clothes brighter, white clothes whiter. Whiter than ever before. Get new Oxidol with green crystals.
Sprite, new soft drink from same company that bottles Coca-Cola.
Sprite, Sprite. Ring-a-ling, sparkling Sprite. Taste the zing-a-ling, sing-a-ling, tingling tartness of Sprite, Sprite.
Taste is tingling tartness in the bright green bottle with a bubble.
Channel 3, Jackson.
This is Dick Sanders with a WLBC WJDX editorial, an expression of opinion by the management of these stations. Tomorrow, the nearly 1,600 employees of the Storkline Corporation, Jackson's largest single industry, will vote on whether they want to be represented by a union for bargaining purposes. This, of course, is a matter for the employees to decide, but from what we know of the situation, it seems to us that the employees stand to lose a great deal if they vote for union representation. First, we don't understand why anyone would want to be represented by the union in question, the United Brotherhood of Carpenters and Joiners of America, AFL-CIO. The Senate Labor Rackets Committee has found that officers of this union seriously misuse union funds for their personal gain. The international president, who is still in office, has been convicted of criminal bribery in Indiana and is facing a 2 to 14-year jail sentence pending appeal. This man, Maurice Hutchison, also has been convicted of contempt of Congress. 2 other international officers who have died in recent months also were convicted of criminal bribery. Second, according to the record of the only plant represented by this union in Mississippi, the New Orleans Furniture Company of Columbia, Storkline employees already are paid more and have more benefits than the union has obtained in Columbia. For instance, Storkline has life insurance, accident and health insurance, hospital and surgical insurance, and sick benefits, while the union contract in Columbia provides none of these. Storkline also has a profit-sharing and retirement pension plan. According to the record, union charges of exploitation do not stand up in this case. Although we are an outsider, we can't help but express the opinion that we hope the Storkline workers reject the union in tomorrow's voting for their benefit and the good of justice. This is a WLBC WJDX editorial.
Deposit Guarantee Bank and Trust Company, whose slogan is Grow With Us, now presents the 6 o'clock news with Dick Sanders reporting.
Good evening, everyone. The Mississippi Senate has passed a bill to merge the 2nd and 3rd congressional districts of North Mississippi into a 24-county district containing 608,000 persons. Following expected passage of a similar bill in the House, Congressman Frank Smith and Jamie Whitten would face each other in the June 5th Democratic primary. The President pro tem of the Senate, George Yarborough of Marshall County, said nobody is happy about the state having to redistrict, but he says the bill is the fairest proposal and would make for an even race between Smith and Whitten. The bill's author, Senator Ollie Knight of Amory, voted against the measure after he unsuccessfully tried to have it recommitted to committee because of opposition that suddenly sprung up in his home county, Monroe County. Most of the debate concerned amendments by Delta senators, which would have taken Tippah, Benton, and Union counties out of the merged area and placed them in Tom Abernethy's district. Senator Jack Tucker and Senator W.B. Alexander argued that the merger would create a district twice as large as all others. Alexander said the bill would create a predominantly Hill district and take away the Delta's right to be represented in Congress. Senator Bill Caraway of Leland said the merger would create the largest district ever created by legislative action in the United States. And he said the plan was, in his words, born out of wedlock and fathered by a many-headed monster composed of power politics, unpledged electors, selfishness, and greed. It was inferred that the bill was aimed at punishing Smith for his loyalty to the National Democratic Party. Well, Smith took the news of the Senate action in stride, at least for the record. Smith said a lot of good people are being put in my district, and he said I'm out busy contacting them. The Greenwood congressman says he will qualify for the June 5th election as soon as he knows for sure what the makeup of his district will be. Jamie Whitten will be favored in the race. He has not been available for comment since the vote by the Senate this morning. More news in just a moment.
Think fresh and 62. Treat yourself and your family to the comfort and carefree convenience of a brand new car. And finance that car the easy way at DGB. You'll appreciate Deposit Guarantee's low interest rates on auto loans, and there's no red tape. You repay in convenient installments designed to suit your income. Get the complete story on the ease and convenience of financing your car at Deposit Guarantee. There's a convenient DGB office to serve you, no matter where you live or work in Greater Jackson. Around the town, it's Deposit Guarantee, whose slogan has always been, grow with us.
In the House this afternoon, a young Biloxi legislator made a charge against some of his colleagues. Representative Jerry O'Keefe told the House that the House Ways and Means Committee killed one of his bills because he had opposed the cigarette tax increase. Charlie Jacobs, the chairman of the committee, called O'Keefe's charge a fantasy. And Jacobs also took issue today with a claim that tax increases are necessary because of the increase in the number of state employees. The Bolivar County legislator said the real reason new taxes are needed is because of the increase in the number of school children in the state. Tomorrow morning, the Mississippi Teachers Association meeting will begin in Jackson. A spokesman for the group says nearly 6,000 Negro educators are expected to attend the three-day meeting. The president of the association, O.E. Jordan of Carthage, will address the opening session. Other speakers for the meeting include a Peace Corps representative, William Franklin, and the executive secretary of the American Teachers Association, George W. Jones. Mississippi Congress of Colored Parents and Teachers also begins a two-day meeting in Jackson tomorrow. The opening session for this annual meeting will be at the Pratt Memorial Methodist Church. And State Senator G.V. Sonny Montgomery of Meridian says although he has had some encouragement from some very fine people, he does not plan to run for U.S. Congress. He said he had been considering running for representative from the 5th Congressional District. More Mississippi news in 1 minute.
This portion of the 6 o'clock news was brought to you by Deposit Guarantee Bank and Trust Company of Jackson, whose slogan is, grow with us.
Hey, what's with the towels, Jane? They're so soft.
You don't say. Hey, Mom, the electricity's gone out of my sweater.
Well, what do you know? You're so right. Your diapers are so much softer, aren't they, darling? Know what's happened at our house? Downy.
New Downy Fabric Softener. A new discovery from Procter & Gamble. Add a little Downy to your final rinse, and Downy rinses amazing softness, deep Downy softness into everything. Makes remarkable things happen.
Downy gets things so soft and smooth, even ironing's easier. Now my iron almost glides by itself. And some things dry so unwrinkly, they don't need ironing at all.
Downy does it all. Get Downy and watch out for flying compliments. New Downy Fabric Softener.
WLBT now presents the second segment of the 6 o'clock news.
2 Meridian housewives who would have been the first women to serve on a jury in Mississippi have been removed from jury duty. U.S. District Judge Harold Cox removed Mrs. Ernest Brookshire on the left from the list of 18 prospective jurors because she had trouble hearing the testimony. An attorney removed Mrs. Walter Hodges in the center on a peremptory challenge. He was not required to give a reason. Mrs. Hodges, along with Mrs. Lucille Bailey of Waynesboro, will return Monday to be screened for service on another jury. The Civil Rights Act of 1957 permitted women to serve on federal juries, but the state law still bars them from state juries. Final news in just a moment.
Every minute your cake bakes, it loses moisture. Look, place a cover over your cake and see. When a cake loses moisture like this, it's bound to lose flavor too. But now, for the first time, there's a cake mix that makes up for this moisture loss. The new Duncan Hines layer cake mixes have an exclusive moisture holding formula that makes up for moisture your oven bakes away. Gives you a cake more moist than any other leading mix. See how moist. Press the cake, and it springs right back. Press. When it springs right back, you know it's moister, tastier cake. Slice a Duncan Hines cake. Tenderly moist. Tasty. Meltingly moist. That's because the new Duncan Hines layer cake mixes make up for moisture your oven bakes away.
The House of Representatives has approved a bill which would raise the speed limit for automobiles in the state to 65 miles an hour. However, the measure is expected to face stiff opposition in the Senate. The original bill would have authorized the Highway Commission to increase the speed limit to 70 miles an hour on interstate superhighways only. However, amendments were adopted increasing the speed limit for automobiles from 60 to 65 and for trucks from 45 to 50. The bill was approved 75 to 53. The National Association for the Advancement of Colored People said today it has asked Governor Barnett to investigate the alleged shooting of a Negro prison at the Hines County Prison Farm. Sheriff's officers were out of town and unavailable for comment. Highlights from today's Mississippi News Scene reported from the WLBG News Department.
Good day.
This could be used in the display
Testing. 1, 2, 3. Testing. Say something.
Testing. 1, 2, 3, 4. Hello, Jack. How you doing?
What you know?
Boy, you're looking slimmer every day.
Man, I'm taking it off.
All these jacks here together, huh? Where's the rest of them? Y'all didn't bring the rest of them with you? Well, we asked Jack to come over here this afternoon and review this, well, I call it the Bruton situation. Appointment of Everett to the Workers' Compensation Commission. Jack's got to be back in court at 3, huh?
No, I've got plenty of time. I've got to leave here by about 3:15 or so.
Well, I advised him anyhow that we would take him up first and let him review this thing with us in advance, and then he can leave when he gets through, and then we'll go ahead and take care of the rest of the business. Hey, Jack, I'm going to turn it over to you and let you explain it.
Yeah, thank you, Claude.
What your researchers brought up here.
As you know, the legislature just before it adjourned passed a bill which raised the salaries of the members of the Workers' Compensation Commission. It raised them about $1,000 to $1,500, depending on whether they were chairman or members. Now, the governor then has appointed, effective January 1st, Senator Bob Everett from Roosevelt, who of course was a member of the Senate and was elected, duly elected in the summer of '59 to serve in the Senate for a full 4 years. And of course he was a member of this, both the 1960 session, the special session, and then the 1962 session. Section I have here for each of you a few things I thought you might be interested in, and you could review them. You'll notice the top item is the bill itself as it passed. Then
simply raised the salaries of the commissioners and gave them an additional referee, you see. Now, Section 45 of the Constitution of the state of Mississippi provides, quote, no senator or representative during the term for which he was elected shall be eligible for any office of profit which shall have been created or the emoluments of which have been increased during the time such senator or representative was in office, except to such office as may be filled by an election of the people, you see. Now, there are two things that emoluments, of course, means salaries, and the definition you get into is office of profit. Now, there are two things that you're faced with immediately that cause problems. Number one is, of course, Senator Everett resigned, and they're trying to get around it that way. You see, of course, the statute is so worded that it passed. The statute is so worded that that gives them a point of argument. I don't think it means a thing myself. And secondly is the definition of an office for profit. Now, before I go into that, I'd like to say this. I think you fellas and your movement have three separate and distinct alternatives in this matter. And if you like, I'll outline them for you. Number one, you can fight this thing in the courts, which I think should be done. Number two, you lost the fight in politics, and you can try to win it back in politics. Or number three, you can forget the whole thing. I think those are your three choices. I favor the first. The Constitution, this matter has been before the courts on several occasions. From time to time, the legislature has created offices, and the most recent case was a case of Nay Gore and the Sovereignty Commission, when he was appointed Sovereignty Commissioner. Now, the court held that was not an office for profit. There are three separate and distinct elements that this so-called office for profit has to have. Number one, the authority that particular officer has must be delegated by statute, which is definitely true of the Workmen's Compensation Commission. Number three, his term of office must be set by statute, which it is in the statute, 6 years. And number three, which is not absolutely essential, but which is an indicator, is that he must be required to put up a bond by statute. As the commissioner is, he's required to put up a $10,000 bond, you see. Now, the question then arises as to whether or not the commissioner, a Workmen's Compensation Commissioner, is an office for profit. Under those three tests, I don't think there's any question that he is. However, there are ways that the court can come out from under it without any trouble, you see, if they want to. I don't think they'll dodge the issue. They hadn't dodged it in the past because they've said rather clearly. I gave you the opinion in the Supreme Court opinion in this Golden case, the Nay Gore case, and the court very clearly stated in that case that if this had been a situation where these three conditions had existed, that is, the authority of the individual is set by statute, the term of office was set by statute, and he required a bond, that there would have been any question about what they'd done. They set the rule out very definitely in this opinion on it, you see. I don't see how the court could ever get around that rule that they've set up so firmly, and it's been said in so many other cases by the Supreme Court, you see, which there are half a dozen cases that have been before the courts. They've held that a levy commissioner was an office for profit, and a member of the legislature couldn't take one of those jobs when it was created, you see. But I think the crucial problem in the case, the legal problem, is this: whether or not, you see, this would have to be, unless you could get the Attorney General to come in on a quo warranto action, which you would have to request, and he'd have to refuse. But if you, of course, if you got a quo warranto action, you'd be in circuit court, and you'd have a pretty good shot at it then, with the Attorney General backing the thing up. He should. He should be called on and to file a quo warranto on behalf of taxpayer, you see. But the thing they're going to come up with in defense of this matter is that this money that's paid the commissioner is not money that belongs to the state of Mississippi, you see. It's money that these insurance companies and other people put up, which they're required to do by statute to operate the commission, you see. Now, that's never been a factor in any of these other cases, you see. But of course, that's, as I say, they've got that. That's one of the defenses they're going to make, and the second will be that Everett was not a member of the Senate at the time the bill was passed. You see, that he had resigned. But his appointment had already been submitted, and you can prove that it had been there for days, and it was just an out. Now, that doesn't bother me a bit. That aspect of the resignation part, that doesn't bother me a bit.
You say there's never been a test of the financial side of this thing, Jack?
Well, if I said that, I didn't mean it. What I meant to say was that insofar as I can determine, there's never been a question just like that. There might have been in some other state something similar, but if there has, I haven't been able to find it, and I've done considerable research on it, but we might can turn up something. But every case that we've located holds that where these three situations exist are normally any combination of the two of them, or the first two. The bond's not necessary, but the first two are. That is, a term of office set by statute, and your delegations of your authority directly by the legislature, you see. In Gore's situation, he was his term of office, he served at the pleasure of the commission, and the commission was delegated the authorities, and they're the ones that had the authority, and Gore simply did what he was told to do, you see. He didn't have any bond. He didn't meet any one of the three of these tests that the courts have set up. Now, of course, you fellas know me, and you know that I'm the only way I can phrase it is I'm just highly prejudiced in favor of Claude Bruton. I wouldn't attempt to make any bones about that with you or anybody else. So when I say these things, I want you to know I'm prejudiced, you see. And you better get some advice from somebody that doesn't have that. It'd be a good idea. Now, I talked to E.K. Collins down on the coast this weekend. I told Claude that I was going to talk to him about this situation, and I assumed that E.K. wouldn't mind me discussing it with you. In any event, I'm going to do it. And I talked to E.K. about all aspects of this thing and told him very much what I'm telling you now. And E.K. told me that there was no question in his mind, but this matter should be resolved in the courts, win, lose, or draw. But he told me that I told him that I had been approached by some of the members of the executive committee, and they asked me whether or not I'd be interested in representing them in the matter, or whoever they decided to handle it. I told him that I wouldn't mind at all. I'd enjoy it. That we batted around a little bit, and E.K. had some ideas about it that I agree with. That this is probably not a matter that somebody that has just one side of it in his mind should handle. it should be handled by somebody that can have an open mind. I mean, that is, somebody should be in charge of it, and that has a completely open mind and is one of the probably more capable lawyers in the state of Mississippi. And he suggested somebody like Forrest Jackson, you see. And I told him, of course, I would convey that to you fellas, which is all I'm doing. And it's a good idea. It makes a lot of sense to me. I mean, I don't mind, as I say, I'd buck him in a minute, but I think somebody like and Forrest has helped you fellas before in the past. I mean, he just, if he thinks you're right, he's gonna help you. I can name. I mean, by the time I was admitted to the bar, and before I ever had any contact with any of you fellas, Forrest Jackson was representing a number of the unions, and I think he's helped your outfit several times, hasn't he, Shay?
Represent the carpenters.
Carpenters.
That's what they're working on.
Well, in any event, I'm just giving you all that information for whatever it might be worth. And of course, I tell you at the same time that if you decide to do it, you want me to help you in any way, I want to do it. I don't care what capacity you want me in, I want to help, you see. I just feel strongly about it. And it's a matter that as far as I'm concerned, I don't think y'all can let it go by default. I think that's what it would amount to. I don't see how you can be fair to the people that you're supposed to represent without going to court and doing everything you can to prevail in this cause and put it to the courts in the best manner that you can possibly put it to them in. Now, there's no question in my mind that you're going to be faced with politics in this matter from start to finish. And it's going to be hard to keep the courts from making a political decision in the matter. And of course, timing is going to be important in it. And whoever you have representing you is going to have to realize that. I think that your timing is going to have to be important. Of course, you're not faced with having to do anything until the 1st of January. And certainly, no public pronouncement or leaks of any kind that might hit the press should be made by any of you until the time comes for you to file the suit if you decide you want to file it, you see. I think it'd be a mistake to do it. Now, as far as the administration of the law is concerned, Senator Everett is a fine fellow. He's a likable fellow, and he's a personable fellow. He's had now, as I say, I assume what we say in here is more or less confidential within the ranks. Senator Everett has had 3 compensation cases. I started practicing law back about the time the compensation law was passed, and that was the way I got into it, because I took some cases when none of the other lawyers would take them, and I like to think that I did a good job on them, and as a result of it, I made some contacts with some of my friends in your movement, and I didn't have those before I started practicing law, but I did, and I came along, and that's about all I do now is this type of work and personal injury and some general practice. But Senator Everett has had 3 cases. In each of these 3 cases, he's asked me to handle them for him. And we've just settled one here in the last few days. And he's got, we had one we settled while he was in the legislature, and I gave him a $2,000 fee on it when we split. It's about $1,600. And then years ago, he had one in my former law partner, Russell Moore. One of them at Delta and helped him try it. In fact, Russell tried the whole thing. So that's been the extent of his experience with compensation law, you see. Now, on the other hand, I'd invite your attention to the 1962 section of the Mississippi Legislature, their handbook. And I would call your attention to the bibliography, the data that each of these men have given in connection with themselves when they were, that is, their background, what they belonged to, and this, that, and the other. I think this is extremely interesting. You fellas might not find it interesting, but nevertheless, I'd like to read it to you. This is what he says about himself and told the other members of the Senate. Robert D. Everett, 29th District, Sunflower, Humphreys, Washington County, born October 7, 1899, in Simpson County, Mississippi. Lawyer, Baptist, Mason, Shriner, Shrine Club, Chamber of Commerce, American Bar Association, President of Sunflower County Bar Association, American Legion, Marriage, Senate, 1956-1960. Now, I don't notice in those qualifications any background that would connect him with labor, you see.
No.
I don't know, but I think I've been around this situation long enough to know what some of these, that one of these particular that's listed here stands for. Now, I might be wrong, but that's what you're faced with. Now, if you think you're gonna get if you think the laboring man's gonna be looked after over there, you're wrong. And I don't think if you went through the courts and lost this thing, that you'd be a bit better off than you are right now. And on the other hand, if you went through it and won, you'd have them standing up and taking notice. I've told you fellas, and y'all my friends, y'all have lost this thing in politics, and I want to get away from this for just a second because y'all are my friends and I don't mind talking to you. I'm talking to you like a friend, and I think you understand that. I'm not being critical, but trying to be constructive. I think when I think the labor movement in Louisiana is a typical example of what I'm going to try to tell you. In Louisiana, when the Council of Central Labor Group there decided that they want to, back years ago, they started out on the county level. They didn't start on the state level. They didn't start on the district level. They started out electing men to the House and to the Senate, or letting them think they elected them, or being a big part in electing them. And these senators and these representatives knew it. And it wasn't until they were respected in the House and the Senate that they moved into state politics. And you know, I don't have to tell you what they are in Louisiana today. And that's typical of the other states that have been successful. And if you would concentrate your efforts on the House and the Senate until, I think you could do it 1 or 2 times, and you would absolutely be amazed at how much more influence you would have. And this is a question of influence. Politics is that's all it is. And until such time as you are respected in that House and that Senate, not because you represent a big bunch of people, but because there are enough of those senators and representatives there that think the way you think. Then until you reach that point, you're not going to be much of an influence in Mississippi politics. Now that's just my opinion. I've told several of them, I think all but you two gentlemen, but that's the way I feel about it. And I think the reason that you've lost ground in this present administration is because you lost in politics and you made some decisions that that you looking back on you might not have done the same thing again if you had a chance to do it over again. But that's water under the bridge, and the immediate situation is what are you going to do on this situation? Now, I've been kind of rambling along. I think I've given you the pros and cons of the situation, and if you have anything you'd like to ask me about this or anything else, I'd be delighted to talk to you about it.
Well, this is still strictly a political question. What if we win? What do we got? I mean, because Ross is still there.
No, wait a minute. This case, this won't have to be filed until January. The campaigns are that summer, you see, and whoever is appointed has to be confirmed by the Senate, you see. And if Bob Everett can't have that job, Ross can't get anybody else confirmed by the Senate. I mean, there's not going to be one, you see. If he calls a special session, he's got to call that special session by November. He's under the gun, you see. And he's not going to call another special session because they're going to cut him up something awful. And you'll have even if you, which I don't think, I think the case could be handled in such a way that it would be a year or more getting to the Supreme Court, you see. Time should be, if it's handled, if it's, you get a lawyer and get to mess around in court, it takes a long time to get into it. And you wouldn't want to finish it up in such a time that Ross would get another crack at it. Well, you just got a year.
That was the point.
You just got a year, you see. But if you went, you got nothing to lose with this case. Even if Ross would get another appointment, you'd made your point. He wouldn't be able to get one that the Senate would confirm. And whoever the next governor is going to really throw a monkey wrench in whatever he does. I don't think I think that can be handled in such a way that it wouldn't be a big factor. Now, this case, this Gore case went to the Supreme Court, and the total court cost on it was $32.70. You see. Now, what happened in that case? The lower court had, as I recall, had gone along with on the pleadings. And they went to the Supreme Court, and the Supreme Court said no, you see, he was all right. So they didn't make any record in this case. There was no record, it was on a demurral. And of course, that's where you get into expenses. But even if you had a record, it wouldn't run over, the worst one I think you could possibly get in wouldn't run you over $300 to $500. And, the only other cost would be attorney's fees. And of course, I told Claude, as far as I'm concerned, I'd do it for nothing. I just want to get a hold of it so bad. I mean, that's what I say. I'm so prejudiced you don't want to have anything to do with me on it. I just feel that way. But whatever you'd have to spend on it would be money well spent, in my opinion. I just don't see how you can let it go by the board. I mean, that's just the way I feel, but I certainly think you ought to get the benefit of other legal thinking on it.
Well, I have, Jack. I've discussed with several lawyers, as I told you I had. And of course, I've got some pros and cons. Of course, you know where some of them were. Of course, they touched on some of the areas that you've already touched on, particularly in regards to the tax monies involved. But I think that you might say is a mute question because your position was created by legislative action, and it support it, do you?
I don't think so.
Of course, this is one of the things that
just like
Kyle's referred to when I discussed about it, but, you know, he immediately raised this question that this wasn't tax money, so I'm assuming that this is where they're hanging their hat.
That and the fact that he resigned before the bill was passed.
Yeah. Well, it's very obvious that's the reason he
the
resigned.
second, the last one doesn't bother me.
No.
The first one is the tax money proposition is the only thing that concerns me in the least. And I don't think that it's in these cases, it hadn't been raised anywhere down the line. It had to be tax money. You see.
It is a tax money imposed by the legislature.
No, well, it's an assessment. It's an assessment, but I think I've been intending to go over to the state law library and see if I couldn't find something on in some of these other states where they've had assessments like this. You know, they do it for banking commissions and different state commissions. Yeah, they assess the utilities or the banks, and they operate like that. I will see if I couldn't find something. If you could find something where assessments were in the same category as tax money, you see, which they are in essence. They're money that the state is assessed, and that's all a tax is an assessment, you see, to operate on. I don't think it needs to stay.
Almost give you that.
What day? Maybe I'm a little confused, but there's a little something in my mind bothering me about these dates. What day did this salary increase bill pass?
All right, here it is. Let me give it to you. House Bill number 79 was introduced January 17th in the House. It was referred to the Judiciary Aid on January 25th. It was reported out of the committee, title sufficient, due pass. On January 31st, it was amended and passed in the House. There was a motion to reconsider. It was tabled on February 1st. On February the 5th, it was sent to the Senate. On May 26th, well, it was it was received in the Senate on the 5th of February and referred on March the 6th to Finance, referred to Finance and Judiciary. It was passed, the Finance Committee reported out on the 17th of May, title sufficient, due pass, you see. The Judiciary Committee reported out on the 6th, title sufficient, due pass. On May the 24th, it passed the Senate. On May the 26th, it was signed by the governor, and
then Bob Evans
became law.
Resigned about the 22nd or 3rd.
That's right.
Well, now that's what's bothering me. The piece that I saw in the paper, and I wished we may have it, where it said that Everett had resigned to accept this position on the committee, said his resignation is effective May 26th.
Well, it'll be a simple matter. I'll have to apologize for not having done it. I intended to do it before I came to this meeting, but that's all a matter of public record. It's just a question of going over to the Senate and looking at it, you see.
Well, I've got that information here. I can get
well, we'll just get the original.
Now, I can be wrong, but that.
Well, all you've got to do is get a copy of his letter of resignation, and it's a simple matter.
They say it was a misprint, you see, typographical error as far as the paper is concerned. That's the reason I mentioned that.
Well, it'd be a simple matter to get that.
Isn't it true that he's been on committee that took action?
Yes, he was on that's the point I was making. He was a member of the Judiciary Committee. Now I went over to the I went through the minutes. I went through the minutes of the Judiciary Committee for the 5th of March when this thing was passed. Of course, he was a member of that committee. Now, it was passed on a voice vote. There was no There was no recorded vote on it. However, the minutes show that he was present and voted. It wouldn't make any, it wouldn't make any difference. It wouldn't make any difference either way. He was a member of the committee that considered this thing.
Well, Jack, give us a little idea if you can. What is your estimate of cost on this thing going into Fort Worth?
Well, as I say, I think your cost would probably run, assuming if you get it in like this, which is a good possibility, this type of lawsuit would be resolved on demurrer and on your pleading, you see. If you did that, of course, your court costs would not run too high. You know, it'd be a question of attorney's fees. And I would suggest that you simply sit down and decide how you, if you want to, now this might be a good idea. This might be a good idea is to go to a lawyer that you have confidence in, Boris Jackson or anybody else. I don't know how you might feel about him, but he's the one that E.K. Collins suggested.
I have a question.
And let me just say this before I say it, and talk to him and get two things from him. Get his honest, let him consider this matter and give you his honest opinion on what he thinks you ought to do. And two, talk to him about the cost. Now, of course, if you were talking to me about what it would cost you and I was going to represent you, I'd talk to you one way. You go to some other lawyer and talk to him, he might want to talk to you another way about money, you see. I would prefer that as far as your legal fees, you talk to whatever lawyer you decide you want to get to represent you on about that.
Do you think that condition retention fee, Mr. Crown Lifetime, would have any bearing on his position in this case?
I'd ask him point blank.
Boris Jackson on retainer with him?
He gets $75 a month, I believe that.
I don't know what it is.
But they've got, yeah, but they've got 250 lawyers in Mississippi that are on retainer. They tried to put me on one. They want to pay me $75 a month 10 years ago.
What they do is try to get all the lawyers in the state tied
so
up.
they wouldn't sue them, you see. And I told them if that's all they're going to give me $75 a month, that I just couldn't be bought that cheap. But he doesn't do any work for him, and he gets that. I know as of 2 years ago he was getting it. I don't know whether he still is or not, but you know, there's some companies that pay me some retainer fees. I get some money from a few companies that I represent every month. And if you would ask me whether or not my relation with those companies would affect my relations with you, I'd tell you right fast whether they would or wouldn't, you see. Or tell you after I thought about it whether they would or wouldn't. And I would say just ask him point blank if there's anything, including your representation of the power company, that would make this a situation that you couldn't give us your fullest efforts in the case. I think you should ask any lawyer that if there's any reason why he can't represent you. And I'm sure that I don't know of any. Well, I won't go that far, but I think most of them, every one of them you'd be talking to would give you a straight answer.
Forrest has been representing the state council department on a retainer basis for years, and also the operating engineers and the laborers. What are other of the labor organizations in the state?
And has done some good work for them too.
Yeah. I raised the question purely because it is of such political nature.
Well, it's a valid question. It's a question that you have no alternative but to ask him. The same would apply to any lawyer that you talk to. You should ask, if you wanted me to do it, you ought to ask me that.
Well, Jack, you were interested in handling the case yourself.
Sure.
I understand. I also understand that there's several other attorneys that would be interested in joining in this case, claiming attorneys and what have you.
Yeah.
Claude Bruton told me Monday night.
Well, there are several of them
That,
that's been extremely.
let's put this fellow's name up at Kosciuszko.
Ford, two of those, Crawley and Ford, and they want to get in it and those two fellows are two of the sharpest lawyers in Mississippi.
I understand that there's several more that
There are.
would
Would that be Dave or Jim? Or some of his
Dave, young Dave, and Bill Ford.
Bill Ford is the guy
I used to know the older Jim.
When those two fellows, particularly old Dave, I never will forget it. He's an emotional fellow, wonderful fellow. He sat in the Senate the day these bills passed and cried.
Yeah.
Damn, I felt so sorry for him. I was sitting up there, of course, it was rough on me, but poor Dave was sitting over there in tears, just rolling down the guy.
I went to school with Dave's sister, Lola Lee Crawley, several years ago,
Y'all got anything else you want to ask me?
No, I don't, not too much, Jack. You in a hurry to get on?
Well, I got 20 more minutes.
Do you recall the incident, the similar situation to this in regard to Representative of Monroe County, Tom Martin, that was appointed on the highway?
Or
something, and he was
appointed.
Fired or something, or you know that you recall the specific case?
Yeah. That was politics, though. There was no threat of any court action in that.
But seemingly there would have been a conflict of interest, as I recall. But I was trying to recall after we started talking to you just exactly what it was that did happen.
I think he had some job over isn't he an accountant? Insurance, something. I think he was over in a tax commission, working over there at some, not in a commission job. I mean, as a commissioner, but in one of the, just working as an accountant in one of the sections, or maybe it was in the motor vehicle, one of the other. Motor vehicle, I believe it was. And Ross just decided he wanted him out, as I recall. It was just politics. They just put the pressure on him so much, and you put the pressure on the motor vehicle controller so strong, and he just had to go.
My question, Jack, was did any procedure develop or anything that we could go through to maintain Claude on the job after we disqualify Claude?
Well, there's a definite cause of action that Claude could take, that he could take in conjunction with this, you see. I'm not, at this point, I wouldn't attempt to advise you on the merits of it. Now, Claude, on January the 1st, was a de facto commissioner. And something he takes over will become what is known as a de jure commissioner. It seems that Senator Everett is holding under a cloud and is not, he's holding office, he hadn't been duly and properly appointed to. The law provides specifically that until such time as a commissioner is properly appointed to succeed another commissioner, that the commissioner that holds that office is the commissioner, and he shall serve without appointment until that time, you see. So if you throw Senator Everett out, then Claude he'd been de facto during that period of time, and he'd automatically be the commissioner at that point, you see. Now there's a suit that he can file on that, an injunction suit that he can file, you see. Now, it might be that that would be your best way to handle this thing. I don't know. I at the present time, I'm inclined to favor the taxpayers route. But there are several avenues. You've got the direct action by Claude, and the only way he can take that is in the nature of a full warrant. So there's no other provision. he'd have to have the Attorney General to file that suit on his behalf, you see. And if the Attorney General refused, then I think he'd probably be out, you see. He could, under some states, our statutes in Mississippi specifically provide in quo warranto actions that they have to be brought by the Attorney General if they affect statewide offices. And all a quo warranto is an action to test the legality of a man who claims to be a public official, you see. And if it's a statewide position, then it has to be brought by the Attorney General. If it's of a local, municipal, or county, then the district attorney is the proper one to bring it, you see. But there's no provision in the Mississippi statutes for one who claims to be a public officer and has been thrown out for one who he claims is not properly in the office, other than this quo warranto, which requires the Attorney General to bring it. And I wouldn't be surprised. I don't know what is say. There's a lot of politics in this thing.
I think probably get Joe to bring that. Right.
And if you could get Joe Patterson to bring that suit on behalf of Claude, then there ain't no question about what you ought to do, in my opinion. Of course, until you make up your mind who you want representing you in this matter, I don't want to put myself in a position of telling you to do anything, you see. And I've tried not to do that, except to tell you that I don't think you ought to let this matter go by default. And I know of 3 different avenues that you can take in the courts. There might be others, but there are 3. And but the course you take, of course, it'll all be the results will be the same. It's just a question of taking the one that puts you in the strongest position. Quo warranto is in circuit court. The injunction, your taxpayer suits in chancery. You see, it's in the nature of an injunction. And the quo warranto is before a circuit judge. And those are factors to be considered. What judge are we going to get this before, you see?
So what would determine which judge it went before, say it went before a circuit judge?
Well, it had to be filed in Hines. It's got to be filed, and it'll have to be filed in Hines County. There's no way around that, I don't believe, because you file it in the place where the officer is holding office. The alleged officer is holding public office, which would be Jackson. And you'd have to file it here. But you know that Stokes Robinson was appointed by J.P. Coleman. And you know that he held in this case that Nay Gore didn't have any business in that job, you see. Supreme Court reversed it. Those are just things that's a little background that you know. On the other hand, you get over in a full warranto action and get into McGowan's court.
You had.
I don't know which that would be, but those are things to be considered, you see. And of course, it would have to be assigned, either Hendricks or if it went into circuit court, McGowan would sign it to either Hendricks or either one of the 2 county judges, and he's not bad about signing any of the cases in circuit court to Carl Guernsey, but he does assign a lot of them to Russell Moore. See? And I would take my chances with Russell Moore in this thing any day in the week. But I don't know whether you'd ever get the chance to do it. That would.
That might influence the assignment.
I believe this. I believe this. I believe this. You could, at the time you filed your suit, you could ask Judge McGowan to assign it to Russell, and you might stand a chance of getting it assigned. I think Russell would be extremely fair, but I know his background. I'd rather take my chances with him than any judge I know. But I don't think his chances of getting him are too great. back to the circuit, back to the Chancery Court. Stokes Robinson's political background I've outlined. Judge Stennett's background, he's a Barnett appointee. Judge Horton was beaten by, he won his race from a J.P. Coleman appointee. So you don't know how you might feel about it. Normally, I would think that Billy Horton would be about as good a friend as Labor could have. On the other hand, that's right. That, as I say, that would be my normal inclination, my normal thinking on it. But those are the factors that you'd have to consider, and of course, whoever you get to represent you, of course, will be cognizant of that situation.
Jack, have you heard any comment on Madison's feeling toward this thing?
No, and of course, I've made every effort not to put myself in a position that I'd have to get it, because that's not my prerogative at this point, you see. I wouldn't want to do anything that would jeopardize the cause in this thing. And I have very carefully avoided it. I've been around him a couple of times, and I've carefully avoided bringing it up, anything that might even lead to it, because I think he knows about the situation.
Well, I'll give you a grapevine if you want to hear it. So, aware of that. And he said if he had given the governor an opinion on every qualifications, it would have been the same as he gave on a similar case on Claude's last appointment. And that was that the party was not qualified. His status as Senator Evers. Is that about what you heard?
Yes, I heard that. He stated that if he was asked for an Attorney General's opinion, that he would have to state that he was constitutionally barred from holding the office. Now, I heard that he said that. I don't know whether there's anything to it or not. I don't know. J.P. Coleman has been not unfriendly to your situation in recent years. He's got quite an influence with Patterson. It might not be a bad idea for somebody in a pretty good position to go talk to him and see what his ideas about it. He can give you the political slants on it, and I don't know. It might be something to think about, the advisability of doing it. Of course, it's not without some pitfalls. It's just something to think about. But I think probably, I don't know, I might be wrong about it, but you fellas don't have too many friends high up in state politics. And the one that I would say would be, at the present time, most likely to give you some consideration would be Coleman. I don't know, I might be as wrong as daylight and dark, but he made every effort in the world over at this last session to be friendly. In my opinion, he could have done a lot more for us than he did. But I'm sure that there was a reason for that. He didn't want to get into anything controversial, and he stayed out of it for that reason. But he made every effort over there to assist me when I was trying to do something in these bills and at this last session on other matters that y'all were affected by to help. He went out of his way to do it. And I think he could, I don't know that he would, but he would come closer to influencing Patterson than any man I can think of. I just give you that for whatever it's worth, not as a suggestion, but as a possibility as to how it might be approached. Now, if you could get the inside information that that the Attorney General would do two things. One, that he'd hand down the Attorney General's seat. Claude is still commissioner. He can ask for an Attorney General's opinion. And he can do that up until January the 1st. And if the Attorney General were to hand down an opinion on January the 1st at Claude's request, that Section 45 of the Constitution barred Senator Everett from holding this office. And secondly, that he would join, that he would, in his name, could be filed a quo warranto action on behalf of Claude Bruce. Then, of course, you'd hit glory road then. Boy, you would be in such good shape, I hate to even tell you about it. But those are bridges that you'll have to cross between now and then. And how to get that done is going to have to be up to you.
Well, this special session is going to be called, be out of town by January the 1st.
Oh, another session next year, even if he has one this fall. Always call one in the last year of the session. I don't think you had a governor that failed, have you?
No, but this matter will be tied up in the courts of politics by then. You might well face it, it's going to be an issue in the next campaign.
Right. That and several more by like
And
similar to it.
I just hope that the organization itself can stay out of statewide politics this time until you can get your feet on the ground. But there's no getting around it. This thing will be an issue in the campaign if y'all do it. And they're going to be branding you this way and that way, which is nothing new. But I think in this you'd be right, and I don't think you'd have any fair-thinking judge that you get before. I think he's going to see it your way. As I say, my ideas are so firm on it that I'm not the best source of legal advice on it.
But you would handle the case, Jay.
Oh yeah, sure, I'd be delighted to. But I'm not soliciting business. I mean, I think you can get better representation. I agree with E.K. that you can get better representation from somebody like Forrest Jackson who has doesn't have a closed mind on it, so to speak. He might, because he doesn't feel as strongly about it, doesn't have, I hate to get in it, just to be honest with you, I hate to get in any kind of lawsuit that I've got any personal feelings or convictions in. You can't do your best work when you're under that handicap. It's just like representing a brother or somebody in your family, you see. You just can't do the best job for them. You want to see it their way. And a lawyer can't go into court like that and very long without it catching up with it and catching up with him bad, you see.
Like a surgeon performing an operation on his mother.
Or his wife.
That's right.
It's the same principle, and I mean, as I say, I wouldn't hesitate to represent you, but I really think under the circumstances that you ought to get somebody that in the category that we're talking about. I think your interest would be better served. As I say, I think I could. I wouldn't hesitate to represent you, but I just think you're, and I'm so vitally interested in this particular situation that I would want you to see. I'd want to see that you got the best that you could out of any legal services that you might seek. And it's not that I feel that I'm not capable of doing it, it's just that I feel that you ought to get somebody that that's not as you might say, your brother in the situation. I'm as much in this as y'all are because I feel so strongly about it, you see. And because of that, it might make it difficult for me to really see this thing when we get into courts like a lawyer should see it, with an unbiased view, and it just there's just good reasons why you ought to get somebody to represent you that doesn't feel that has convictions that your cause is right, but doesn't have the convictions that it's absolutely right and damn everything else, so to speak.
Jack, regardless of who we select, you're going to be involved in it anyway, aren't you?
Yes, sir. I hope I am. I hope y'all see fit to let me do anything I can.
Well, now that you said that, why don't you do this? Why don't you name over several people that you'd rather work with?
Well, as I say, I think I'm not. There are a lot of good lawyers out across the state that would like to be in this thing, and don't feel as strongly as I do about it. The Corley and Ford up at Kosciuszko, whom I have the utmost respect for, are wonderful lawyers. Of course, Forrest Jackson here is one of the greatest lawyers I know of anyway. I don't think he's surpassed, and I don't know of any lawyer that surpasses him in the courtroom, both in ability and the manner that he handles himself in. He's just a great lawyer. Of course, I feel the same way about old E.K. Collins and Whitman Ross down at Laurel. There's old man Homer Pittman down at Hattiesburg. You could just go on and on. I mean, it'd be much easier for you to name them. Let me tell you what you think about them. Carl Ginsberg down on the coast, and Pascagoula, and Donald Cumbus, and just anywhere you go, you're gonna find Richard up in Columbus, old Richard Carlisle, and anywhere you go, you got lawyers. That's right, H.D. Carter, and Van Everett. You got good lawyers all over the state that be just tickled to death to represent you in this matter. And I don't think, as I say, I don't think any of them would have as closed mind on it as I do.
Have you happened to have had occasion to discuss this particular thing with Homer Pittman?
No, I hadn't. Not this particular thing. The situation generally I have. I know he feels he's off of Ross's bandwagon, but good, you know, and he's one of his colonels.
Yeah, I knew he was.
I mentioned this thing just in a casual conversation with H.D. Carter. I'm from Columbus, and I know H.D.
I know that. That's the reason I mentioned. That's the reason I mentioned his name.
I said to H.D., looks like that this ought probably be the right way ought to go on the thing. What about this plaintiff attorneys association getting in on this thing? He said, well, I'll tell you right now, my service is available free.
Well,
he feels too.
That's the way. Well, now let me say this about the Plaintiffs Attorneys Association. Of course, I've worked with them for years, and they have we have mutual interest, you see, and the legislature and the Manufacturers Association, the Economic Council have done their best to label the Plaintiffs Attorneys Association and the State Labor Council as one and the same, you see. And the further we stay apart, the better off we're going to be. This is your fight. and not the Plaintiffs' Attorneys Association. That's my opinion. Now, if I think you'd find that if Plaintiffs' Attorneys Association were asked to join this thing, it'd be right in there. And I feel sure that when it gets to the Supreme Court, that there'll be an amicus curiae filed by the Plaintiffs' Attorneys Association on it. But I don't think that the Plaintiffs' Attorneys Association should take any active part in it until it gets to the Supreme Court for final determination. However, if it's felt that it should, I'm sure that we could bring them into it without any effort at all, because E.K. Collins is the state chairman of it, and I don't have to tell you what a friend of ours E.K. is. He's an old mine worker. He was an organizer.
He helped organize Masonite. Yeah, he helped organize Flintco.
Yeah, not many people know that, but he's an old mine worker, and boy, he made the circuit with it. But I'm not trying to avoid your question, but there are just so many of them that are confident. Y'all got any other idea?
Well, we'll kick it around here, Jack, and let you know.
All right, I can talk to you.
We'll let you know what we decide to do.
Yeah,
appreciate you coming over.
Well, I'm delighted that you asked me.
And I appreciate what you've done. As you said, the material you brought along with it. We feel pretty strong about the thing.
Well, it's just possible that any way you go is going to be wrong. But on the other hand, as I say, I just don't see how you can let it go by default. You got too much involved, and if you don't make a scrap for it, they're gonna take everything you got away from it.
Well, that's all we got anyhow.
Good. Sorry we didn't have no cigars, Jack.
I came with one and I worked through it.
Maybe we'll have one next. Maybe this board can straighten out the Secretary of Treasury this afternoon.
All right, I hope you will. Next time you invite me down, have a couple of good cigars. Y'all ought to reinstate old Ramsey's pay there, because usually he's got one I can lift out of his pocket. See you later.
Okay, Jack.
Well, I'll get out of here and get my cigarette, see if that thing's working, Tom. I seen that last flash it's in.
Yeah, well, I beat it and banged it.
You ready to go? Right where you left it, buddy. Yeah. It was picking it up all right. Well, fellas, we've got several items that we need to pick up with you here this afternoon, and I would suggest first that we dispose of this workman's comp thing that we had Jack in and discuss with us about first, while it's fresh on your mind, so to speak. I think probably the best thing to do here is to get an expression out of each one of you of what you think about it, and we'll just go around the table. Marvin, would you like to express yourself on it first?
My thinking on this is pretty well what it's been all the time. It's an important matter. It's a thing that if we let go by, it'll be forever gone, in my opinion. The question that has been in a lot of our minds, I think, all the time is possible financial conditions, as to taking in consideration the fact that it's as important as it is. Also, it's important that we have the necessary finances, because we don't know exactly where we're going to go, how far we have to go, and what it'll cost exactly. But I would say this, that generally speaking, if we feel like that we can afford the thing financially, then we can't afford to let it go by.
Well, in reference to the financial situation, we will bring you up to date on that. I think this is a very definite part to it. You know what I'm talking about. That's the reason I made a point to ask Jack to try to give us some rough idea about what the cost of this thing would be, and he pointed out to you what possibilities were and so forth. What about you, Jack?
Marvin's pretty well expressed my sentiments. Very frankly, we can't afford to pass it up if we can afford it. Win or lose, I think we stand.
We're going to have to make an effort. Finances, irregard, you know what I mean. That's kind of part of it. How about you, Jim?
Well, actually, I mean, the conversation I heard today puts a different light on it, you know, especially if it's a change of Claude going in there. I was a little bit in doubt as long as it was a possibility. I mean, of losing the case, plus if we won, he turned that around and appoint someone worse than that. And, you know, as I'd hate to jump out of the frying pan into the fire, but I mean, if it's a possibility, I'm in full agreement. It's just this idea. I mean, he could, like I say, some have stated that if he had another shot at appointing somebody, he could pick somebody a lot better. I mean, somebody that was more or less a labor hater.
Well, he's limited as to what he can do under the language of the act. Of course, Jack didn't go into in this meeting very much with the act itself and the requirements there. He concerned his remarks more around the constitutional provision on this salary increase phase of it, which I think is the strongest point of the case. But in presenting a legal argument, I feel reasonably sure that this matter will be dealt with extensively. The act itself, which requires that a man by vocational affiliation should have a labor background, more or less to that effect.
Well, to me, that is, although that might not be the strongest legal point, but actually, to me, that is the strongest point as far as we're concerned.
That is our point. No question about that. Of course, the matter of blocking this appointment, possibilities of securing that relief, I think, centers around the salary increase phase of it more than anything else, right? You want to express yourself on it?
Well, of course, Claude, since Jack said some things he did this afternoon about the various lawyers, and of course, as he said, it pointed out that he was rather prejudiced. It seemed to me like that maybe the best thing for us to do would be to decide here who, if any, of the lawyer that we would want to contact on this thing. I'm thinking now, particularly with reference to the legal expenses, you know what I mean, and get, I think what Jack was saying, that he might quote us a price that he would charge, and maybe another lawyer would be altogether different, see. So, I mean, I feel that we ought not take this thing laying down. It's a real disgusting situation. But at the same time, we all agree that we have got a money problem.
We've got to consider the money angle.
We've got to consider that, but I do think that we should decide here, and maybe the committee should direct you to contact somebody, and if that's their, you know, idea on the thing, and get a price, you know what I mean, and then we would be in better shape to decide further as to whether we could try it or not, you know what I mean, from a financial standpoint. Well, I think we have to go in this thing with a full knowledge that we'd probably wind up Washington with, you know what
I think this might be a good possibility of getting this thing blocked here, though, with this course here. I really do, with the angles that Jack pointed out. Well, I think we're in agreement then. The committee is in accord that it's a matter of principle and it's a matter of necessity that we will have to take court action on this thing, Well, we're not. The only problem centers around that of finances. Now, I have discussed this thing rather at length with Jack Travis, and of course I've discussed it some with several other attorneys, but not as much as Jack, because Jack is close and I saw him quite often during the legislative session and requested that he do a little research and meet with the committee in here. And of course you heard him and he expressed himself rather frankly about how he feels about the thing. I've been advised that there are a number of attorneys that would be interested to assist in this thing free of charge. See, I have been advised of that.
I have a suggestion, though, that Claude talk with Bruton. Frankly, I don't know of a man with any better opinions about attorneys on something of this nature than Claude. Now, I'm still a little skeptical of Forrest Jackson, although I do think he's a good attorney in many ways. I think we should at least get Bruton's opinion on Jackson for a case of this nature. I'm inclined to think that he would go along with it if Jack Travis has the regards for him as he has. I do know that Bruton has an awful lot of respect for Crawley Ford. And I would also suggest that we consider in talking, if it's agreeable with Bruton, Forrest Jackson, and probably make a little run up to Ford and Crawley.
Well, I think if we decide to go to court with this thing, that this is probably what will take place. I think some of these lawyers you just named, who are members of the Claimant Association, will probably file in front of the court brief, as Jack outlined, Amos Curry brief here earlier. They will participate in the case as a friend of the court, so to speak, or you know what I mean, friend to the suit, friend of our case, which means that they would be in a position then to assist whoever the attorneys we engaged. You know what I'm talking about. I disagree with Jack's philosophy on this thing to a certain point, that he's so highly prejudiced about the thing that he wants to go with it. I would rather, I'm inclined to want an attorney that feels pretty strong about this kind of a situation. You know what I'm talking about myself.
I think that's good once you get in it, with the preparations for it. Often your prejudice feelings, you fail to see the defendant's position too. So I think that's, once you get in it, I think you ought to be completely sold up.
Well, you've had the carpenters I know have used Forrest Jackson for a number of years. Building trades groups have used them more or less, to my knowledge, and he's done most of their legal work, particularly on the state level. I think his background is more or less pro-labor. We know that. The only question would be about this retainer business with the Power and Light Company. Would that be it?
Right.
Well,
now we know
if
the
you
fire company is a big part of this Barnett faction.
Yeah. Yes, that's true. Well, now, the financial end of the thing, it's going to be kind of hard to figure just what this thing will cost us when we go into it, as Jack pointed out to you. But I think as a matter of principle, as a matter of necessity, that we've got no choice other than to go to court with this thing. Now, if we follow Jack's advice, and I've discussed this thing with him at length about what the possibilities are, this is what it will be. This suit would be filed at the end of this year, which would mean we'd have this thing tied up in court, see, as he pointed out to you, which means that Bruton should stay on the commission follow it through as he suggested with the Attorney General's help and so forth. This would be our pitch anyhow to maintain Bruton on the commission. And even though he didn't stay on the commission, we would block Everett's appointment probably most of the year, which means that this thing would be in the political arena part of the whole thing. We would probably have commitments out of Coleman or whoever's running here about this thing once it was resolved. You understand what I'm talking about? This is where the getting Bruton reappointed comes into the picture. The other phase of it is this, is that that even if we don't get Bruton reappointed, he will still have to appoint someone as specified in the act. And it'll be pretty doggone hard for him to get an enemy of labor on that commission following the language of the act out. You see what I mean? So I don't think we've got any choice in this thing. And I've given this thing an awful lot of thought, but to go to court with it. I don't think they've left us any choice, because they hit us right smack in the face with this thing and completely ignored the language of the act and everything involved, right?
I agree 100%.
See? Now, the financial situation is this. The council is not in the best financial shape in the world. There's no question about that. We've been in that shape for some time. Prior to the convention, we had picked up and was in fairly good shape, but we had some additional expense that won't be reoccurring for a while, and if we maintain our present affiliations and even pick up some, then we will be in better shape as time moves on. I can't foresee right now any big expenditures outside of normal expenses. You understand what I mean? Now, the convention roughly cost us about $3,000, everything included. You see what I mean? We had to spend about $1,500 in addition to the kitty we had on legislative expenses. And this happened this past month. This was part of the new equipment, of course, that we had to purchase, but it just hit us now. Spent $800 on some new equipment, a desk and a typewriter for the other office girl. We just got around to paying for that, getting that installed. That's a total of $5,300 in expenditures that we've had to put out in the past few months that we won't be faced with as we see it in the immediate future. You understand what I mean? Now, at the present time, we've got a balance of $6,257 in the bank, but there are checks out now. Part of this is part of that, which brings that down to about $2,000. That means that there's around $4,000, $4,500 in the bank at this time. That's what the assets are now. That means that we're back about where we were around the first of the year. I've got financial statements. I keep a running check on this thing on a month-to-month basis to see about what the financial picture looks like. See, we were down to $3,589 on December the 31st. January the 31st, $4,700. February, $6,691. March 31st, $9,510. We got some payments, dedicated assessment, so forth in that. Month of April, $8,375, and then I just quoted you the May figure for at the end of May, $6,000, which means that we are operating, fairly well breaking even as the situation goes, in spite of the fact that we spent $5,300 that won't be reoccurring. Of course, the whole thing centers around the affiliation and the payment of dues and things of this kind. So I think we'd be safe here and saying if we could obligate ourselves for a couple of $1,000s without being bankrupt. You know what I'm talking about. And I don't think, as Jack outlined here, that this thing would cost us that much money right off the bat.
Claude, I might add this to what you're saying. dedicated assessment became effective the 1st of August. Well, it's now the 20th of June, and I think in the next 30 days that we'll be having some payments on dedicated assessment come in here for the next 12 months. See, some of them paid it a year in advance, so it's reasonable to expect some year payments on dedicated assessment within the next 30 days. So that should
we hope that happens anyway.
You're back up. So
what I was getting at, you did, is there any other locals besides that Woodward local you can talk to about this would be a good change?
No, I haven't. I'm going to
Natchez.
I'm going to Natchez week after next, and I intend to talk to that rubber worker group. What he meant was that I went to Laurel the other day, and I made it a point to talk to Mr. J.D. Jolly, the business agent at Woodward Local, and told him that it appeared that we might have to go to court with this thing, and I wanted to know if we could expect any assistance out of them and help them pick up the tab if we did, that they had a stake in it too. See? And he told me he felt that they would be able to help us some. So we could put the bite on some of these groups that are not affiliated. I think we might get some help out of it. Don't you think so, Jim?
That's the point I was trying to get across. Those that are not affiliated, we might can still, this would be a good chance to put a fight on. We might get enough out of them to put the cost.
Yeah, I think we can get some out of them, because they did kick in all that right to work thing. They sent us $1,000 on that, and a fight of this kind, I think we might get some out of it. Jim, we'll turn him loose on that, right?
I can get them money so far when they would get, except for affiliation.
Might familiarize them with our work a little better too.
Yeah. Well, what do you fellas think we need to do with the thing now?
Well, it looks like we're down to the question of who we might put on the preferred list.
Yes.
And I don't have any axe to grind, a pro or con on these fellas. It's plain, I'm more or less go along with Mr. Travis decided that a lot of these people would probably be good people to have. I'm inclined to have a little leaning toward Forrest, but I wouldn't want to. I'm a little bit prejudiced. I'm like Jack now. I'm being perfectly honest. I'm a little bit prejudiced in favor of Forrest, but at the same time, with the angle that Jack makes over here, I wouldn't want to jeopardize the situation. If that's what we're going to talk about now, as to who and so on.
I would suggest Bruton be given some consideration on it.
We discussed a matter of what lawyers we entertain.
Pardon?
And what lawyers we entertain.
Yeah.
Or we
If he has
retain, rather.
If he has no objections to Jackson certain hire, I think he's a good lawyer.
Well, I think we could put the thing like this, that I think first thing we need to do, though, is to get a motion on the record here that we will write the minutes up, that we do initiate court action on this thing, and then make a decision as to the...
I so move that we do initiate court action if feasible.
I'll second the motion.
Well, we have a motion and a second that the exec committee initiate court action on the workman's compensation appointment of Bob Everett to the commission. We have any further discussion? All in favor of the motion, let it be known by saying aye.
Aye.
Motion carried and so ordered. Now we can take up this question of the attorney. If you would like, this of course I think will probably have to be handled with Tom and myself, acting in committee's behalf. If you'd like to authorize us to make these arrangements, we can handle it in this fashion. That we can consult with both Claude Bruton and Jack Travis before any arrangements are made. Understand what I mean? And I think we at least owe Jack this much of a courtesy,
And when we do, let Jack know that we want him to participate in this case, right? Even though we might engage someone else, huh? I go on with that. Bye-bye. All right. Now, if y'all got other ideas on approaching that thing, well, it's all right with me. It looks like we're gonna have to
Well, that's about all we
action
can
along
do.
this line some kind of a way, you know what I mean? Of course, the first thing we'd have to do, I think, is to discuss the thing with, get Ruben's attitude on it. Then if, Forrest Jackson, he found no objection to Forrest Jackson, then we'd first have to go over and talk with him, find out from him what his opinion was, what he felt like it would cost, you know what I mean, things of this kind. And it might be that the figure he'd quote us would be out of reach. We might have to reconsider this thing and engage even Jack or somebody like that, you know what I'm talking about.
Would this, would the political angle need to be considered in the selection of an attorney? Now, this whole thing will be pending during next year, and if Mr. Travis has indicated, it'll certainly have some political repercussions.
Yeah.
And thinking in terms of that nature, sometimes who the attorney is that would be carrying the ball on this thing could have some definite political repercussions.
Certainly could.
And I was just wondering if, in the selection of a person, if that shouldn't be taken into consideration.
Let me ask you this, Marvin, where was Forrest Jackson in this governor's race in 59? Do you know? Did he make his position known, or did you have any occasion?
I didn't have occasion to know, and I really couldn't say. I've had some curiosity myself, personal curiosity.
He wasn't active in the campaign. I mean,
No,
we
he
know
wasn't.
about it.
But frankly, at the times that I've been with him and around him, associated with him, that there's been no subject that would lead you to take even an uneducated guess on that point.
Might be the time person again, and if he wasn't associated with anybody, publicly and so forth, you know.
He's always supported Democratic ticket.
I rather think so. Now there, I think, would possibly come in maybe the necessity or maybe the advisability of talking to JP.
Yeah.
As to what political implications might be involved in this thing, in which direction it might go, or turn, or take. See what I mean?
It'd be a good idea to go see him before we talk to anybody, you know, before we engage any attorney.
That's my make on it.
Might be a good idea. Sure might be.
We won't muddy the water. In other words, if you can get two jobs done down the road, sort of in the same direction, then you're doing pretty good.
I'm pretty sure Forrest Jackson made a contribution to the Democratic headquarters down.
I think he did too.
I think I remember
I think I remember what he made. I think I remember him
his
making
name being on the list. You know, people contributed to the whole thing down here. I think it was.
Well, he was an old Bilbo follower. Bilbo always stayed with the Democratic Party. He was a New Dealer, so to speak, on everything except the race question.
Oh yeah, that Bilbo had some very liberal ideas.
Oh yeah.
Even in state politics.
Yeah.
He always carried every vote in Mound Battle precinct. Never did fail to get every vote in that box. I couldn't figure that.
Well, what do you fellas want to do with this?
I would suggest that you talk to Bruton and Travis, make the second move probably to J.P. Cole. And then if Jackson is all right up to that point, approach him and get his approximation on finances. And it might be that we have to change our plans after that.
That meet the committee's approval, done in that fashion?
Yes, sir.
Yeah. Right, then let's do it that way. There's no need adopting a motion. We've already adopted a motion to initiate court action, and if they're in agreement to follow this procedure, engage an attorney and so forth, then we'll follow that course of action. All right, we've got several other problems here that we need to resolve with the committee. We've got several requests from some local unions for exoneration for payment of dues. We touched on this, I believe, at our last meeting, immediately after the convention. As a matter of fact, we had a little session with Frida Guyton, I believe, wasn't it? Yeah. Discussed 2 or 3 of those local unions in the Amalgamated Coal and Workers Group. And we have got some correspondence from several of those locals requesting exoneration. So at this time, I think we ought to dispose of that matter. Tom has the correspondence from those groups, and I'm going to ask him to read the letters he's got.
The first letter I got, as I had it, I believe, before. Matter of fact, I got this one before the convention. I think I mentioned this to you all down in the Heidelberg coffee shop. It was from Marion Ingram, who is business agent for clothing workers in Columbia, local 708. And here's what he said. At the regular meeting of local 708 in Columbia, Mississippi, incident, this letter was dated April 18, 1962. 708 in Columbia, Mississippi, on the 5th of April 1962, the local voted to ask the Mississippi Labor Council to release them from paying into the council per capita tax and dedicated assessment until they were better financial state. The reason for this contention, I guess, is that they work on government work only. And in the last 8 months, very few people have been working compared to what have worked in the last 36 months. Hoping this will explain the situation to your satisfaction. Thanking you sincerely, Marion Ingram, business agent. Now, I had jotted down here what their standing was. Columbia paid per capita tax, excuse me, Mississippi Labor Council. Just a minute, operator.
Hello. Yes. Yeah. Oh, pretty good, I guess. Oh, yes, sir. How you doing? Take care of it one way or the other. All right, you read the
as I was saying, the Columbia local paid the per capita tax and dedicated assessment through February. Now, that's where they stand now. And of course, I said this letter was before the convention. This is the only letter I had. You want to do this one at a time? You want me to go ahead?
I think you ought to read them all at one time.
And I've got a letter here from Louisville, Mississippi, local 720 of the Amalgamated Clothing Workers. It says, due to financial conditions of local 720 Amalgamated Clothing Workers, we are requesting that per capita tax and dedicated assessments be waived for this local until such time that our finances allow us to resume payment thereof. Thanking you for your cooperation in this matter, we are fraternally yours, Edna Parker, President, Emma Miller, Secretary, Treasurer. And that was dated May 1st. Another one dated May 2nd. Due to financial conditions of Local 701 Amalgamated Clothing Workers, we are requesting that per capita tax and dedicated assessments be waived for this local until such time as our finances will allow us to resume payment. Thanking you for your consideration in this matter, we are Clarence Robertson, President, Helen Gooden, Secretary, and Myra Sybil Reel, Secretary Treasurer. This is Macon.
That's right.
And then I have one dated May 8th, 1962. We regretfully request exemption from paying per capita tax and dedicated assessment to the Mississippi Labor Council until such time as our local's treasurer will permit our resuming payment again. Thanking you kindly. Eternally yours, Annie Hugh Boyd, President, Blanche Reed, Secretary. This is Local 758 in Walnut.
Well, in the first one, we're clearly within our rights. Right. Because
In the worst situation.
Now, they state the reason. Others doesn't even state a reason why they're in financially bad shape.
I might add that I talked to Marion last week, and he said that the company had bid on another contract, government contract, and it looked pretty good for a little later on, but it was critical now. The people, there's just a very few people working in the plant, and he said that he is hopeful that by this fall that the people would be back on the job. The company thinks that they, as far as they know, they are a low bidder on a pretty big contract, and he said that if they could get a little relief for the time being, the people got back to work, my everything would be all right.
I think we can handle a Columbia situation like that. It'll definitely try to, because clearly stated there, you know, that the work situation is really a problem, which you'll turn on page 15 of the Constitution and 15 and 16. Page 16 in particular, it's a section that deals on, section 8 deals with the situation. It lists the reason for financial difficulty caused by strikes, lockouts, or unemployment of its members. It shall report such circumstances to the Executive Committee, which may, if convinced the circumstances justify, instruct the Secretary Treasurer to waive such per capita tax and dedicated assessment from month to month.
That's Local 708.
I didn't, here's one thing I didn't give you was the information on the other locals I read. Macon, capital tax dedicated assessment paid through March, 62. Louisville, per capita and dedicated assessment through March, 62. And Walnut, per capita and dedicated assessment through March, 62.
He answered each one of those letters and advised them that we'd have a meeting with the Executive Committee in the near future, no matter what we presented to the committee. That was done also.
I make a motion that Local 708 be exonerated according to Article 10, Section 8 of the Constitution.
Section 8 of the Constitution. We have a second. Any further discussion? Not all in favor of the motion, let it be known by saying aye.
Aye.
All opposed? Motion carried and so ordered.
I would also offer a motion that the Secretary carry out the proper correspondence
point out to them the limitations on the Constitution.
Right.
For means for exoneration. You offer that motion.
Right.
You have a second?
I'll second that.
Before I put that motion, I want to point out a couple of things to you here. Of course, I think in writing this letter that Tom will have to point a few things out. Of course, I'll try to help him in the drafting of the letter because it's going to be an important letter because of the situation. I've given this matter a lot of thought. I imagine all of you have. And it's the most difficult kind of a situation to deal with. Now, as I viewed the thing, the committee is going to be setting a precedent. Whatever's done is going to have to be done with understanding that that rule can fit anybody, any local union. Now, if this local union, these local unions, the situation being what it is we know what it is, reaches a point that they can't pay per capita tax because of the overload they've got, and not brought about by, unemployment and so forth. We could advise them that the most that could be done under the Constitution, as it's written, we're required to enforce, is that if they became delinquent and couldn't pay their dues, that the committee would give serious consideration to bringing them back as a new affiliated local union when they were in a position to pay per capita. Now on page 15, let's look at section 6, and I'll show you what I'm talking about. The old executive committee had authorized Brother Knight and myself on several different occasions on locals that had become delinquent to re-affiliate them as a new affiliate and waive the payment of fines and assessments and so forth. This is what I'm getting at. Read that section.
Page 15, section 6?
Yes. Right at the bottom, the executive committee may modify the reinstatement fee where extenuating circumstances exist, which in their judgment warrant such action.